Oops. Good afternoon, everyone. I'd like to welcome you and our good friends from C-SPAN to the McGowan Theater in the National Archives building in Washington, D.C. for another of our noontime lecture programs. I'm Doug Swanson, Visitor Services Manager for the National Archives Museum, as well as one of the public program producers for programs just like the one you're going to see today. Today's noon lecture talk is Redemption Songs, Suing for Freedom before Dred Scott, and is being presented in conjunction with Black History Month. This book can be used as a great teaching tool because it's comprised of 14 chapters that read like short stories, and you can read one chapter per day. So we strongly suggest that if you are interested in Black History Month, to go ahead and buy this book. But before we begin today's program, I'd like to have you join us on Monday, February 13th at noon. Former CIA Station Chief in Afghanistan, Robert Grenier, will discuss his book, 88 Days in Kandahar, a CIA Diary, and how the U.S. defeated and chased the Taliban out of Afghanistan in 88 days in the months after the 9/11 attacks. Then on Monday, February 23rd at 10 a.m., K.T. McFarland will moderate a panel discussion in our Nixon Legacy series, Détente and Arms Control with the USSR. To find out more about these programs and our exhibits, you can take one of our monthly event calendars, which you will find in the racks in the theater lobby, or else you can visit our website at www.archives.gov/calendar. Our topic for today, as I said, is Redemption Songs, Suing for Freedom Before Dred Scott by Lea VanderVelde. Ms. VanderVelde is the Josephine R. Witt Professor of Law at the University of Iowa College of Law, where she teaches work law, constitutional law, and legal history. With the Guggenheim Fellowship in Constitutional Studies, she is pursuing the possibilities that digital technology offers for researching thousands of documents and accounts about the antebellum frontier. For her current project, The Law of the Antebellum Frontier, she is a principal investigator at the Spatial History Lab at Stanford University, using GIS mapping as well as social networking mapping and textual analysis techniques. She hopes to create several detailed accounts of the expansion of U.S. sovereignty between 1796 and 1857. Redemption Song, Suing for Freedom is her second book, following her 2009 book, Mrs. Dred Scott, A Life on Slavery's Frontier. She is also at work on a monograph entitled The Master Narrative of 19th Century Law, which explores how master-servant law resisted the forces of modernization. Among VanderVelde's articles on the legal history of work are The Legal Ways of Seduction, The Gendered Origins of the Lumley Doctrine, and The Labor Visions of the 13th Amendment. Her works on contemporary legal jurisprudence include Walmart as a Phenomenon in the Legal World and the 13th Amendment of Our Aspirations. She has visited and been in residence at the American Bar Foundation, Yale Law School, the University of Pennsylvania Law School, NYU, Stanford, and the Juridicium of University of Vienna in Austria. Please join me in welcoming Lea VanderVelde to the National Archives.
I guess I should say good morning. It's still morning, right? A few minutes till noon. I want to thank the National Archives and Doug Swanson for this opportunity to speak. It is particularly a pleasure for me since it's Black History Month and because the stories that I'm about to tell you about are heroes of Black history, in my opinion. In the history of the United States Supreme Court, there's one and only one case where a slave challenged his master, and that's the notorious Dred Scott case, Dred Scott versus Sanford. That a slave would lose doesn't seem surprising. That a slave would sue at all does. After all, what could slaves do anyway? They had no agency. They were born, died, had children, and worked for other people's gain. But far more often, they were persons who were acted upon. They were bought, sold, transported, sent, bequeathed, and inherited, but they themselves did not buy, sell, contract, and inherit. Slaves inhabit their master's agenda. They live through their master's agendas and lives during the time of their enslavement. The subject and subjective quality of their lives is overtaken by their existence as objects, and as objects who belong to somebody else with a subjective life. And as such, slaves are often unnoticed. It's hard to find details about the lives of enslaved persons. And they're described in the passive voice as having the characteristics of objects. There are many lawsuits that involved slaves. The law books are full of them. They took place over the heads of slaves between free persons. Slaves did not sue. I wrote a book about 300 who did. And, surprisingly, the majority won. This species of lawsuit is rare indeed. In freedom cases before Dred Scott, the slave was pit directly in fierce opposition to his or her master. What was a freedom suit? How did a slave get to court? How did a slave get a lawyer? Well, under the procedure set out by a Missouri statute, the slave began a lawsuit by orally telling his case, his life story, to a court official, a clerk of court, or a justice of the peace. The affidavit told the slave's story, and the clerk wrote the story down, and then the slave signed with an X, customary for illiterate persons. I've arrayed some 300 X's here, which were the signatures of slaves in freedom petitions. The X is made at the bottom of an account of the slave's life, and it must be remembered that slaves were forbidden to learn to read or write. So for these individuals, it was probably, most probably, the very first time they had ever held a pen in their hand, and they were making an X in defiance of their master to assert their freedom. These cases are the original filings at the trial court level, and so there is a lot of detail. They're authentic accounts in many instances that you cannot find other places, about people who you've never heard of before, but who live fascinating, interesting lives. And the petition reads as if sometimes the clerk simply took down the dictation of what the slave had to say. There's a story behind every one of these X's. Behind one X, of course, is Dred Scott, notorious, the case, unknown, the man. Behind another X is his wife, Harriet. But there are others, many more X's than pictures. This is Lucy Delaney, who signed an X when she was just a child and then lived to write about it after the Civil War. Swansea Adams, who's one of the Duncan slaves, which is one of my favorite stories in the book, because it's a story in which there is a superb victory for all of the Duncan slaves over all of their Duncan masters. But behind each of these stories is a family or an individual, and altogether, many of these freedom suits were family affairs, whether the litigants sued jointly, in tandem, or in succession. A total of 160 persons of the 239 for whom we have records were in a family. They sued as a family. Consider then some of these X's clustered together as mothers and children, as brothers and sisters. There are some 11 litigants for whom we have simply no legal records at all. But of these, 153 were women or girls, and 126 were men or boys. Most of the petitioners based their claim on the fact that they were taken to a place where slavery was banned. There are some other bases in the book, as the book explains, but the primary centerpiece collection here are slaves who, by living and working in free territory, not as a runaway, but with one's master's consent, could be in a position to redeem their freedom by going to court. The bondage of the slave was broken by living and residing in free territory. Crossing that boundary with one's master and remaining there a while made the bondsman free. The rule was that simple. These cases were the centerpiece of St. Louis freedom suits, and the cases were fomented through westward migration and national expansion. The rule of freedom by residents living on free soil was essentially derived from migration, and in these cases, from westward migration of owners with their slaves. In these cases, the petitioners directly opposed their master's wishes. They petitioned the court to override those wishes because for some time in the course of Western migration, that person had lived on free soil. These cases were truly transformational. Most slaves were brought west by floating with the current down the Ohio River. The northern shore was free, and Missouri's longest border was with a free state, Illinois. This border had to be passed by or passed through in getting west. The business of St. Louis was as the marketplace for the West. St. Louis was the end depot for most westward immigrants. It was the place to change steamboats, whether you're going north, whether you're going south, or whether you're going further west on the Missouri River. And disputes brewing elsewhere were funneled into the St. Louis courts by gravitating to this transportation hub. A steady stream of petitioners satisfied the criteria for freedom by having lived on free soil before arriving in St. Louis in a slave state. St. Louis was then the natural catchment area for slaves who had experienced a mixed pattern of residence in the course of migrating west. St. Louis was the perfect storm. The Western labor market needed slaves. St. Louis-bound slaves were brought down the Ohio River principally to tame the West. They were needed as domestic laborers in order to advance the processes of settlement faster than could be done by the do-it-yourself yeomen, farmers, and merchants. Slaves occupied a slightly different role in the West than they did in the South. First, the slave men were needed as the muscle to move the cargo, to supply the West, and to provide for Western expansion. Second, in a few limited areas, particularly where there were lead and salt deposits, slave men were set to work in mining. These were jobs that free men did not want to do, and you could not find large numbers of free men to do these jobs. Hired labor was available only at a premium, so slaves were imported. And third, slave men and women were brought into the antebellum frontier as labor to provide the basic needs of sustenance for things that could not be bought in the market, for jobs, tasks, errands that could not be hired. Slaves were available for settlement, lands were available. There was a lot of land in great supply. You could buy a farm for a far less amount than the cost of a slave. Slaves were set to work building cabins, ice houses, fences, stills, chopping wood, making fires, feeding and watering people and animals, cooking, laundering, and where there were travelers, providing for those travelers. In remote areas, slaves provided the labor of basic household sustenance so that that community could gain on the equation of bare survival. Who could build a state, attend a court, found a school, build a library, or form a legislature if all hands were needed simply to maintain survival? Only when some household members were freed from the tasks of maintaining survival could the community build the infrastructure of roads, governments, and institutions on which to advance. Work done by slaves permitted the settlements to advance faster than the settlements could have done without them. The goal of freedom in these cases was always the same. Freedom was the ability to go and do and serve whomever one wished, and just as important, to refuse to obey others who had no legitimate claim to them at all, and also the freedom to remain in place if they wished to, not to have to run and to keep running. These cases highlight also freedom's opposite, the power of enslavement that can be exercised without any accountability whatsoever. The litigants entered the courts in different ways, and they paid different prices for winning their freedom. The price of freedom promised to them by law was surprisingly high for many of these litigants. I wrote these stories by looking at the X's and reading backward, reading at the accounts, the petitions that the slaves had given for themselves, had provided in the elements necessary for the lawsuit to establish their freedom, and then constructing the world around them. Could I verify that they had in fact lived in this particular place in Illinois for 3 or 4 months? Surprisingly, in many instances, I could. I checked censuses, I checked tax records, I checked homestead records, I checked everything available in order to map the world through which these slaves traveled in order to find the story behind the X. Each of these chapters is a different short story, and the slave's subject life is at its center, with the redemption song, the transformative moment. And I'd like to tell you about just a few of the stories. One is Peter McNelly and his wife Queen. Peter's case is the very earliest case to be decided under the Northwest Ordinance determining slaves to be free. This is decided before 1800 in an area that's now Indiana, Vincennes, Indiana. This story had never been told before because it was hidden in the papers of a private collector, and it is also the only story occurring in the book that takes place in a free jurisdiction. Peter and his wife Queen are suing for their freedom in Vincennes, Indiana. It should have been an easy case. Peter's story demonstrates the difficulty of establishing one's freedom in a relatively unsettled portion of the United States territory. Peter and his wife set off from Kentucky for free land, for free soil. But two persons traveling alone and camping beside the falls of the Wabash River were quickly noticed by the Indian tribes who occupied the area. We don't know which of the tribes captured Peter and Queen, but they were taken captive and held for several days, and then they were taken to Vincennes, their very destination, but they were sold to the people in Vincennes as slaves. The Indians got 2 rifles and some ammunition, and Peter knew exactly the price on his head for the trade. Well, Peter is living in free territory. He and his wife are sold to a man named VanderVelde, and they basically stay with him for the winter because there's no place else for them to go. They had to wait until spring, until the very first judge came to the territory for the very first time before they had anyone to appeal to, and Peter wasted no time. He approached the judge on the very day that Judge Turner arrived. Judge Turner quickly saw that Peter deserved a writ of habeas corpus and should be freed from his master, and that Peter also probably was entitled to some money for his treatment. But he allowed Peter and Queen to go back to the putative master, Mr. VanderVelde, And that's where a conspiracy began. Peter's story is the story of a perfect conspiracy. It's almost the blueprint for one. How you separate one slave from another, how you deceive them, how you send them off on an errand, only be taken captive. And what was the objective here? The objective was to keep him away from the judge. Well, Peter is later freed. The story is a dramatic one. But there's one further note. Peter was actually a soldier in the Revolutionary War. I found his veteran's pension. The two men who kidnapped and tormented him are far better known because they have counties named after them in Indiana. Jean-Marie was born in Illinois. Jean-Marie, sometimes called Jean Mary, depending on whether you were pronouncing it in the French that he grew up in or in English, which was customary in St. Louis. He was born to a woman who was enslaved by the French and had been brought into the area before it was even deemed to be American territory. Jean-Marie fought for his freedom and the freedom of his wife and his two children. He was kidnapped twice and shipped downriver to New Orleans twice in manacles for sale. And twice he beat them back, escaped, made his way north, and sued for his freedom. The first time he sued for his freedom, he sued in St. Louis, appealing all the way to the Missouri Supreme Court. I was able to find that on the day that the Missouri Supreme Court ruled in his favor, he had a party. I know that because the people who lost tried to bring an action for disorderly conduct against him for creating such a ruckus. Well, that wasn't the end. He was kidnapped one more time, and this time sent back to New Orleans. There, he filed suit again in Louisiana courts, appealing all the way to the Louisiana Supreme Court. And Jean-Marie and his family ended their lives in freedom in St. Louis. Lydia Titus established her freedom very early in Illinois. She went on to marry a freedman, and together they were homesteaders. They purchased 160 acres, they built a farm, they raised livestock, they had a family, they raised their children. And at one point, her husband died. Several years after that, on one fateful night, heirs of her former master, a generation later, appeared at her door under the cover of darkness and forcibly kidnapped her children and grandchildren. With them was Illinois Secretary of State, who was acting as their lawyer. The Secretary of State was a large man, very imposing, and he said that he was doing this for the law and his clients. He also wielded a gun, and he made Lydia lie face down on the floor while her children and grandchildren were taken off in a wagon. Well, grandmother Lydia wasn't going to allow that to stop her. So the very next morning, she was at court before court even opened, filing a freedom suit to get their return. These cases are full of paradoxes, so when the sheriff found Lydia's children and the kidnappers on a road south, he arrested them both. The kidnappers, because they had kidnapped Lydia's children for their own safekeeping, and all parties were housed in the same jail. Lydia eventually frees her children and her grandchildren, but at some cost. 2 of her children do not survive the ordeal. They die in the cold jail. And at the very end, the homestead that she had built up with her husband had to be sold to pay her lawyer. David Shipman's story is a far more uplifting one because David Shipman was a Kentucky mill owner, and he was falling into debt, and he knew that his creditors would come and seize the slave family if they could. He wanted them instead to take the mill, take the livestock, And so in order to free them from the prospect of being captured and sold at auction, he took them first to Indiana and later to a Quaker settlement in Illinois, and he gave them their freedom papers. There was enough money left behind for his creditors, but his creditors wanted the slaves because, remember, a slave was more valuable than a farm. So they went after the slaves, kidnapping them from this Quaker settlement near Peoria, undercover in the dead of night, and a team of Quakers set off after them in another canoe. The whole fracas ended up in St. Louis with a freedom suit filed by the family. Eventually, everyone became free, and they all inherited the property that David Shipman had bought for them. Lea VanderVelde lived a double life. She was something of a gangster's moll. She was playing off two black men at the same time, one her husband and one another handsome young dapper barber. And as she was running this boarding house, she was also the head of a gang of riverboat thieves who lived at her boarding house. She importuned wealthy men who came to town, finding out exactly how much money they had, and then sent the thieves to get the goods, to get their money, to steal their chest. And this went on for quite a long period of time. Lea was incredibly clever about this because she was always in church proclaiming her love for Jesus on exactly the moment that the thieves were grabbing the goods. She had an alibi, and she made a point to sit near the front so she would be seen. Now, Lea placed her children in the minister's home for guidance, and periodically over the course of her life, she went to court, not because her freedom was uncertain, but in order to leverage someone who had threatened her livelihood. Light-skinned Eliza Tyler was deceived in one of the worst possible ways. She lived with an African-American man as a common-law wife in Goleta, Illinois. And one day, a slave trader offered her common-law husband money to sell her to a brothel in New Orleans. She was light-skinned, and so she could bring a higher price. She was deceived into boarding the first steamboat, but by the time she got to St. Louis, she figured out what was going on and quickly made her way to court before she could be hustled off to the second steamboat. Hester Norkin was given papers by her master for herself and child. He moved to New York. He didn't need a slave. She lived independently in St. Louis for a while among a community of free blacks. And one day he changed his mind and traveled to St. Louis and tried to sell her and his own child into slavery. She filed a freedom suit and was freed. But one of my favorite stories is the story of the Duncan family. The Duncan brothers, black brothers and white brothers. Imagine that when Jesse Duncan died, his 9 black slaves were divided in a will among his 6 white sons. They all share the last name Duncan in the common parlance of the day. Each of the white Duncan brothers inherited a different black Duncan slave, and the white Duncan brothers were quite wild young men. Each one had a different vice. One was subject to alcohol, one was subject to gambling. None of them were really womanizers. The one who got married left his wife after he had 6 children with her and went off to join the rest of the brothers. They drank a lot, they looked for get-rich-quick schemes, but basically they did no work and they lived off their slaves. They supported themselves by living off their slaves. There was a sandbar in the middle of the Mississippi River, and they could smuggle their slaves from one place to another, back and forth, up and down the river, mining in lead, mining in salt, working wherever they could assign them. But for the next 30 years, one after another of the black Duncan slaves established his freedom and worked to get the others out. Person after person, purchase, lawsuit, escape, lawsuit, escape, kidnap, lawsuit, escape. And at the end of 30 years, the 9 black Duncan slaves, some of whom were brothers, had become the most upstanding, leading, established black men of the community of St. Louis. They had founded a church, started businesses, married and raised families of their own, while the white Duncan brothers lived out their wastrel lives, and one after another died in poverty. In perhaps the perfect irony and poetic justice at the very end, the black Duncan brothers bought the remnants of inheritance that were given to their previous masters. Well, I called the book Redemption Songs because it's a metaphor for the voices of the subordinated people who have been silenced in history. It's redemption because it refers to the person's transformation of status from slave property of another person to being a legal person, an independent person themselves. And it's a song because it follows a discourse that has a particular set of conventions that go along with this kind of lawsuit. It's a song sung by the slave, him or herself. A slave is trained to answer his master and to suit his purposes. Yet in suing for freedom, the slave defies that master. When one sings a redemption song, one speaks truth to power, but not the full truth, because a slave is not empowered to tell the full truth. Just enough of the truth to be upsetting to the master, to make a sound discordant with the legitimacy of that ownership, and yet enough truth to meet the elements necessary in order to establish that redemption. That much and no more. At the crux of each of these cases is a story, which I've tried to tell from the petitioner's standpoint. It's written from the slave's perspective, and these petitions are seeking the slave's own objective, which is freedom. Historians of the antebellum America have strained to hear the muffled voices of the silenced population. And slavery itself created that silence, and yet here is a chorus of songs. Each story has a structure. It has a beginning, the petition. It has a middle, the lawsuit. And it has an end, the judgment. They're contested discourse. There is a call and a response. There are depositions and witnesses that fill in missing notes. The singer's not alone on the stage. The song can be drowned out by other voices who can sing more loudly, because free persons can sing more freely than petitioning slaves. What these cases are unlike in other songs is that these are not cases of rescue or mercy or grace. These are cases of entitlement. And so the voice has to be skilled, and it has to speak more carefully. There is a spareness to some of the songs, conserving the political economy of the resistance that it presents. And then each redemption song ends by fading off into the quiet of private lives. These lawsuits are dramatic and transformative, just like songs. Thank you very much. I would be delighted to respond to any questions or comments, and I've been advised to tell people to go to one or the other of the microphones because it's necessary for the recording.
Thank you. Could you address some of the procedural aspects of the cases? Were these pro se? Was there a group within the legal community that was seeking out these plaintiffs? And were they jury trials or judge trials?
Very good questions. Thank you for asking those. There was a statute in Missouri that appointed a lawyer. There was no cause lawyering that I could find at this time. So the lawyer would be somebody sitting in the back of the courtroom who was going to be hearing another case, who had some spare time, and the judge would just appoint them. In the context of these cases, the remarkable fact that a lawyer was appointed at all is really amazing, because in most procedural cases, to bring a case in paupera means you only get the fees waived. Here, these individuals were appointed lawyers if they had enough stated to make out a cognizable claim. The cases were tried as often to juries as they were to judges. The juries were all white, they were all men, and surprisingly, more than 100 times, they ruled for the slave.
This is a difficult question because it isn't in the legal arena. It's perhaps more historical or psychological. But after your research and writing, were you able to draw any conclusions as to the psychology of white America during this time?
Yes, I think that I hope I'm responding to your question. Tell me if I'm not. With 300 cases, you have a lot of cases to compare. And this is a lot of paper, it's a lot of individuals, it's a lot of minutes of time that is going into these lawsuits, that's documenting these lives. The most interesting psychological fact that I discovered, that I learned from this, was about the fact that none of these people filed lawsuits impulsively. They knew what they were doing. They took their risk at a particular time. They thought about it. Often they had a claim for freedom long before they actually filed suit. But they needed some further trigger that meant that staying in place was going to be that much more uncomfortable than going through the process of bringing suit. They knew that if they brought suit, they might end up in jail, as Lydia's children were put in jail for their safekeeping for several months. And so the filing of suits were not done impulsively, recklessly. These individuals always had to calculate the strategies of survival with the resources that they had. And that's the psychology that I found most interesting.
But my question didn't go to the psychology of the slaves filing suit, but
sorry.
to white America on the other side of the lawsuits.
Yes. The interesting thing about these lawsuits and this statute is that one would think it wouldn't have even happened at all. And I did a lot of research into why it is that this statute ever got passed in the first place. And it got passed for a reason that doesn't have, strong resonance for us as doing the right thing. It got passed for the reason that Missouri entered the Union as part of the Missouri Compromise that took its name. And so Missouri enacted this statute because it saw itself as sorting out. They had come into the Union as a slave state, as Maine had come in as a free state. And so they felt that they needed to maintain the balance and sort out the individuals who came to Missouri. There was no abolitionist in evidence because preaching abolition was illegal. It was criminal during the period of these lawsuits.
filing a lawsuit today is complicated enough. I'm curious what you found in regards to people becoming educated. You show up on your screen there, X's. It would be very difficult to have faith in somebody who said they will lead you through a lawsuit. Can you talk about how they found out from word of mouth, how they could find freedom through a lawsuit?
Yes, I think that this had to have been through the networks in the free black community. There was no one who was leading the charge. Each of these individuals stepped forward. That was surprising to me. I thought I would see a movement. I didn't see a movement. So my understanding is that through word of mouth, the fact that this very simple rule meant that if you had resided in free territory, you would be free, was the kind of information that would spread through the community. And recall that there were always about 6 or 7 of these cases going on. So people could watch these cases occurring, and they would know when a judgment of freedom was announced, and one would expect that within the city of St. Louis that information would spread, and spread like wildfire.
Given the number of court cases here, some 300 that ruled in favor of the slaves and their freedom, how one-off or how unique is Dred Scott that ruled in the opposite direction?
Exactly.
And, the ripple effect it had, the impact it had, that it seemed like at least Missouri law was going in this direction, which is the total antithesis of what Dred Scott did. Could you comment on that?
Yes, indeed. If you look at Dred Scott in isolation, you think it's just predictable that a slave would lose. But Dred Scott was a game changer. Dred Scott ended the freedom suits, which is why the book is called Suing for Freedom Before Dred Scott. After Dred Scott, there was no longer a basis for bringing suit because one had been in free soil. So Dred Scott silenced the freedom suits in the face of a remarkable amount of legal activity that had gone the other way for 3 decades.
My question is related to that. With so many lawsuits being filed for freedom, did you find any common thread about why only Dred Scott made it to the Supreme Court and none of these other cases did?
Yeah, that I actually covered in my first book, Mrs. Dred Scott. And I came to the conclusion that the Scott family was unbelievably unlucky. And it's not just one instance. It's the fact that if they had been able to go to trial the very first time, they would have been deemed free because all the other cases that year were being found free. But their lawyer had just left town. And so they, just before trial, was assigned a lawyer who didn't know what he was doing and messed up. That was the first time they went to trial. Then they were delayed by a fire that burned out 16 square blocks of the town and cholera. And no one could be called to jury because nobody would show up. People were dying in the largest epidemic that St. Louis had ever had. So for a full year, there were no courts. There were no trials. During the course of this long 11-year trial, the nature of Missouri changed. 3 new judges took the bench in Missouri, and it's only a 3-judge bench, so that's everybody. And those 3 judges decided against the notion of freedom by residence, the first game changer. Now, Dred was an aged slave with tuberculosis and probably not worth a whole lot at the time that he filed suit. But what was at stake was his wife and his daughters, who were young and vital and healthy. And Harriet filed suit as well. If Dred Scott had a separate case than Harriet, and Harriet's had gone forward, instead of putting the wives under the husbands, Harriet had a stronger case, and the case would not have gone forward, and Dred could have bought his freedom for very little money. So the circumstances were circumstances of extreme misfortune. And, you know, it's a misfortune that we all share.
Just another question. About a week ago, there was an author came, Eric Foner from Columbia, and he has a book, Gateway to Freedom. And in that book, I found it amazing that he mentions how the extraterritoriality principle was written into the Constitution, which allowed for the fugitive slave law, that you couldn't take slaves. Well, if you took a slave across into a free state, it was now the burden on the state to help the individual retrieve it. But prior to the Constitution, under English common law, it was this freedom principle that it was up to the individual to chase after your property, like if a horse ran across into a free state. But I found that absolutely amazing, and he talks about that in his book and how two delegates from South Carolina wrote it into the Constitution, and he sort of implied that they kind of knew what they got away with. But it set up this whole paradigm of, it changed the common law to a constitutional law. It gave rights where there were no rights prior, and it set up all these fugitive slave acts in all these cases. If you just sort of comment on that, I would appreciate your insights into the whole constitutional issue of how this got written into our law when it was not there.
I'd like to mention that on January 29th this year, the 150th anniversary of the 13th Amendment occurred. And it's the 13th Amendment that reversed that language in the Constitution. I don't know why we don't just expunge it from the Constitution, but we don't do that. It's still printed in the Constitution. The fugitive slave clause is still in the Constitution, but it's intricately tied to the Dred Scott case because the 13th, 14th, and 15th Amendments use the language of the Dred Scott case, and they repudiate the language of Justice Taney in the Dred Scott case in finding the language necessary for those three constitutional amendments.
Thank you.
Yeah, thanks again for your talk. I was curious, I think you mentioned some of the kidnappers in one of the cases actually have counties named after them. I was curious if the current residents know of the history, and I was curious about your thoughts about, I guess, more recent attempts, especially in Hollywood, to, I guess, give more attention to some of these untold stories like 12 Years a Slave and Belle and other movies of that ilk.
I thank you so much for your comment, and I agree with you, and I appreciate that insight. I'm quite certain that the people of Indiana don't know that these two counties were named after individuals who perpetrated this kind of torment and kidnapping. And the reason that I can be fairly certain about that is that until I found these papers, nobody knew of them. The papers were in a private collection. They really hadn't seen the light of day. They are now in a collection of the William English papers of the University of Chicago, but nobody's really ever linked them up with the two individuals who have had counties named after them. It would please me no end if instead the names of those counties would be changed. But I don't think that the people of Indiana know that yet. Well, thank you very much. I'm waiting for my host. I really appreciate your coming. I appreciate your interest. And I hope that you can see in these stories of heroes who we have overlooked and stories of individuals who we should really honor. Thanks very much.